There is no expression of support or expression of personal views within this podcast. As a result of recent public interest in the application which is to be considered by the Home Secretary, we have asked a lawyer to explain what it is that the Home Secretary will be considering.
Assalamu alaikum, brothers and sisters. You may have seen the news yesterday. We're recording this on Thursday, the 10th of April 2025. We may have seen the news this morning actually. Headlines like Hamas court challenge to the Home Office. We're sitting with Daniel Grütters today. Thank you very much for meeting us. He's one of the barristers instructed by Riverside Law on behalf of the client, Hamas, the Islamic resistance movement. So I guess my first question is, are we breaking the law right now?
No, we're not. What we're doing today, as far as I'm concerned, is explaining what this application is saying and what it's seeking to achieve, and really explaining the arguments that Secretary of State is now going to consider. And so we're just helping your viewers understand what it's all about. What we're not doing, and what is a criminal offence, is expressing views or beliefs that are supportive of a prescribed organisation. And that's certainly something that we will not be doing today, because that, of course, is a criminal offence.
So just to be clear, and in yesterday's press conference, which we published some clips of, you mentioned alongside your colleagues that showing support for this case, or the arguments within the case, shouldn't be construed or is separate from showing support for Hamas or any other organisation. In doing so is still a criminal offence.
Exactly, and that's very important. This application does not give people the possibility of expressing support. That remains a criminal offence. People should not do that. But people can support the application because there's good reasons why people may wish to support that application that have nothing to do with the prescribed organisation itself. And I'm sure we'll get into that later, but as long as people make that distinction, and as long as they don't veer into territory where they're expressing beliefs or opinions that are supportive, they can support the application.
Yeah. So speaking of which, I want us to basically have a good understanding of what the case actually argues. What's the case? Tell us a bit about the expert witnesses. So just give us a crash course in the case, if you don't mind, because it's been less than 24 hours, I think, since it's gone live, and it's hundreds and hundreds of pages of what appears to be, from a layman's perspective, really well argued case with lots of famous, well-renowned experts contributing as experts with reports and so forth. So, where do we start? How would you like to explain this case to our viewers?
Sure. So I think a helpful way of starting is by explaining that the application has the legal submissions, which are quite extensive, 106 pages, I believe, is how it's come out. And then there's expert reports in support of the application. And those reports, as you said, come from a variety of sources, academics, lawyers, journalists, and the like. And it's people who have knowledge or expertise on topics that relate to the background of the application, and that are intended to assist the Home Secretary in understanding this very complex context in which this application is being made. So those are the two parts of the application. And we can talk a little bit later about what the various expert reports are. But the application itself sets out, summarizes the context that the application suggests is important for the Secretary of State to consider, and refers the Secretary of State to all of those expert reports. But it also summarizes the context. And what the application then does, it says, well, here's the law on various topics relevant to this application. And then the application sets out 3 grounds which the application invites the Secretary of State to consider, and which the application suggests to the Secretary of State should lead her to conclude that Hamas should not be prescribed, but instead should be de-prescribed. And that is a process that Parliament has provided for under the Terrorism Act 2000. And it's really a question of due process. The previous Secretary of State in 2021 decided to ban the entirety of the organization of Hamas. And Parliament has said when that happens, the organization or person concerned should be able to apply for that decision to be different. And then if but that's what the process is about. So what the application then does, so we can go in a little bit more detail if you want. But
before you go into, just to clarify, it was only, not many people remember this, but it was only less than 3 or 4 years ago that they actually did become a proscribed organization in entirety, right? So
exactly. So the Al-Qassam brigades, often referred to as the armed wing of Hamas, was prescribed as early as, I believe, 2001. But it was in 2021 that the then Secretary of State, Priti Patel, decided that the distinction that the prescription had maintained between the armed wing and the political wing, in other words, those with weapons and those who are running the civil administration in the Gaza Strip, that distinction was artificial and that she was going to ban the entirety of the organization. So that's indeed relatively recent. And one of the things the application sets out is the sudden departure that the application suggests that decision represents from what had been the government's approach to that distinction until that point. And that's one of the ways in which some of the arguments are being explained in the application.
Mm-hmm. And she did come quite some criticism as well from many commentators when it came to off the books visits to Israel and alleged kind of influence from Netanyahu and his cronies. But out of interest, how many countries actually in the world proscribe Hamas in this way? Is this like is the UK part of like the majority of the world here, or?
So just to take one step about your comment about Priti Patel, so one of the, and this might help explain what some of the expert reports do. So for example, one of the experts that has contributed several reports, Professor Avi Shleim, who's of course an eminent expert on matters relating to Israel and Zionism. And that's one of the topics that he covers in his expert report. He talks about Priti Patel and her relationship with the certain officials in the state of Israel and the manner in which she was asked to leave a previous government before she returned as Home Secretary in a subsequent government. So it's that type of background where it's experts that have written up these reports setting out relevant facts, and that was considered a relevant fact, so that it can help again the Secretary of State understanding that complex context. Look, I'm an English barrister. I understand English law and English legal systems, and I understand the prescription system in the UK. Other legal systems have other ways in which they can ban organizations and the consequences that those bans have. It's my understanding as a person who has an interest in these sort of questions, that there's not that many countries that have banned Hamas, at least not in the way that the Secretary of State has in the UK. But there are various countries that have, and that have similar provisions in place. So I think it's a bit of a mixed bag. It's probably, my guess would be there's probably more countries that don't do it than the countries who do it. But yeah, that's a matter potentially for the Secretary of State to consider whether that's a relevant consideration, how other countries look at it.
Okay, thanks. So you were explaining the background.
Yeah. So what the background section does, which is quite extensive, it explains some of the background to the organization. So it sets out the foundation and what it claims to have been its purpose. It talks about how the organization changed during the Oslo Accords and the elections that took place following the Oslo Accords. So the application explains that and the interaction with some of the other political factions, Palestinian political factions. So it goes into quite a bit of detail about the history. It deals with the difference between what's often called the 1998 Charter and the 2017 Charter, and how the organization seems to have developed the way it expresses itself, at least, and potentially the way it views itself and its role in the conflict. So the application sets that history out. And again, that is done by referring to some of the experts who have studied the organization in an academic context and have written books about it. And their expertise is in a way summarized by the application in those sections. And again, it's to give the Secretary of State the necessary context of understanding what the organization claims to be about, as described by academic experts, not just by the organization themselves. I mean, the application does have witness statements from the organization, and those obviously provide information as well for the Secretary of State.
The charter and yeah.
Exactly. I mean, I won't go through every single section, but then there's a large section on the British support for Zionism. And what the application seeks to do, it tries to explain to the Secretary of State that the British state historically seems to have provided support for the Zionist movement and then subsequently for the state of Israel. And the application suggests that was the wrong thing to do strategically and morally. And then the application suggests to the Secretary of State that this may be a moment for the British to take a different approach from what it historically has taken. So there's a whole section on that. History, starting as early as the Balfour Declaration of 2017 and going up to...
1917.
Partly, 1917, yes. Going back all the way to 1917 and then up till contemporary, what the application calls the contemporary British support. And that refers to some of the direct actions, for example, that we're seeing in the UK in the response of the British government to that.
Direct action, you mean?
Well, so the application sets out that there are weapon manufacturers that are based in the UK that are producing weapons that the application suggests are being sent to Israel and are then being used in its genocide in the Gaza Strip. And the application suggests that Britain allowing those manufacturers to be manufacturing weapons in the UK is a form of support. It also makes reference to the so-called spy flights that the application suggests journalists have reported on happening. That British planes are flying over the Gaza Strip.
Amounted to material support for...
Well, exactly. So that's what the application argues, and what the application asks Secretary of State to consider. So that maybe is a good opportunity to sort of dive straight into the first round of the application, which is basically to say the United Kingdom has obligations under international law, and the way that the Secretary of State exercises her discretion in relation to which groups she does and doesn't prescribe should be consistent with that obligation. That's the argument that the application, the first round, makes, and it specifically makes arguments in relation to the crime of genocide, the crimes against humanity, including the crime of apartheid, as well as the crime of illegal belligerent occupation. And what the application does, it sets out, in relation to, for example, the crime of apartheid, it sets out judgment by the International Court of Justice from last year that deal with the policies and practices of the State of Israel in the occupied Palestinian territories, and the conclusion of the ICJ that the State of Israel is practicing has practices and in relation to Palestinians that are discriminatory and that are in breach of the prohibition on apartheid. And what the application says, here's the foremost international judicial body setting out that this crime is being committed, and then suggests that the British government has a duty to end those type of crimes from being committed.
So you mentioned apartheid, genocide, and occupation. So apartheid and genocide are things that, in its public discourse, the British government doesn't appear to have accepted yet. And the issue of genocide, the trial on the merits from the ICJ is going to take probably years, right, in terms of giving an official kind of ruling that this is genocide. But when it comes to occupation, does the British government, the British state, refer to any Palestinian territory as occupied? Are you not aware of that?
So let me just take you first back onto the genocide point, because yes, it's you're correct to say that the British government hasn't, or at least the application doesn't suggest that the British government has accepted those allegations. But the application suggests that that doesn't matter, because the question at this point for the British government isn't necessarily whether a genocide is actually happening. That is, as you say, something that is going to be debated in the International Court of Justice in due course. The application does set out the fact that organizations like Human Rights Watch, Amnesty International, Médecins Sans Frontières, as well as various students of or scholars on the Holocaust. So, for example, the application mentions Amos Goldberg, mentions Omar Bartov, mentions Ras Segal. These are scholars, and the fact that they, in their expertise, consider that a genocide is taking place. So the application sets out the reason why it suggests that a genocide is happening. It sets out the evidence. But crucially, the application explains that even if it transpires in the future that a genocide wasn't happening, and that all those organizations and those scholars were wrong, the key point is that it's plausible that there may be. And that's what the ICJ effectively held in the case with South Africa, where South Africa said, well, we can argue about the details in due course, but at the moment, if a genocide is happening, that should stop, because it's obviously, it's irredeemable. If it is happening and we find out years down the line, it's too late. And so the question for the International Court of Justice there was whether or not it was plausible, and the ICJ found it was. What the application says is that fact in and of itself, and all the evidence that South Africa has put forward, and all this other evidence, is enough for the Secretary of State to consider that there's a possibility that a genocide is happening, and that is enough to trigger the duty to prevent the genocide from happening. Because what international law, the Genocide Convention, the duty that it has developed, the Genocide Convention makes it clear that it's not just about punishing people after they commit a genocide, but it's to prevent it, of course, because it's the most horrific crime that exists. And of course, in the wake of the Second World War and the Holocaust, there was a great sense by those who drafted and then the state parties that became parties to the Genocide Convention. There was a great sense of, we can never let this happen again. And that's why there's a duty to prevent it. And that's the argument that the application makes, which is to say, there's real, the application says a genocide is happening, but it also says, even if you disagree, there's enough evidence to suspect that may be the case, to trigger your duty to take every reasonable step to prevent it.
So that's on the issue of genocide. Even if they don't accept that a genocide is happening, the fact that there's a trial going on, the fact that the ICJ has said is a plausible case for genocide, triggers their duties under the Genocide Convention. That's what you're saying.
Exactly, and that's where the application makes the argument to say the organization that's actually trying to end that genocide by military force is Hamas.
Okay.
And therefore, regardless of the views that the Secretary of State may have of Hamas, the application says that you should not inhibit that organization from its ability to resist or end and prevent that genocide from happening. So that's the argument that the application makes, and that the Secretary of State now has to consider.
Okay. But does the British government refer to any of Palestine or historic Palestine as occupied?
Yes, so the consistent position, as I understand it, of the British government, which is consistent with the consensus, the international consensus, is that the territories that were occupied by the State of Israel following the war in 1967, that those territories
They're referred to as occupied.
they're referred to as the occupied Palestinian territory, singular. So even though it's not continuous, that is considered the territory of the Palestinians, and that occupation is illegal according to the International Court of Justice. Again,
It's illegal.
That occupation is illegal,
Yeah.
and that is one of the other arguments that the application makes. It refers back to the judgment of the International Court of Justice, dealing specifically with the occupation by the State of Israel of those territories which it occupied following the war in 1967. And it says that that occupation, not only is it an occupation that has discriminatory practices, such that it segregates and breaches the prohibition on apartheid, but also that it's illegal, and that it should end as soon as possible, and that it should compensate the Palestinians for the losses they have suffered as a result of that occupation. And again, that decision is crystal clear as to what is happening in those territories and what is right legally and what is wrong legally. And the British government's position on the judgment itself, I believe they are still considering it. I believe when they were last asked about it, they said they were considering a judgment, which it's a long, detailed judgment.
Is that the one from 2024?
24. That came out last year. There's another judgment from 2004, which is even older, which is often referred to as the Wall opinion. So in that case, was again an advisory opinion, so where the United Nations asks the ICJ to give its expert opinion on a matter. And there the question was whether the wall or the separation barrier that the State of Israel was building in the occupied West Bank, whether that was lawful or not. And the argument the State of Israel effectively made was, well, this is for our safety. And the conclusion of the International Court of Justice was, well, that may be the case, but the land on which you are building and the land that you're expropriating from the Palestinians belongs to the Palestinians, and for you to take that land, even if it's to build a wall or separation barrier for the purposes of safety, is unlawful. If you want to build such a barrier or wall, you should do so on your own territory. So that's the 2004 opinion, and that, of course, was premised on the idea that the West Bank was occupied, and that the Fourth Geneva Convention applied to that territory and limited what the State of Israel could and couldn't do in those territories. And it made it very clear that those territories are the Gaza Strip, East Jerusalem, and the West Bank. And in that position, the reason, of course, why the ICJ expressed that view is because it's a consensus view amongst most countries in the world. And there's really only a really small group of countries that disagree with that, one of those being the State of Israel.
What's the British government's view on that then?
Well, as I understand the British government's view is that...
because they appear to have quite staunch condemnation for settler violence and in the West Bank and the building of settlements and so forth. Almost like a completely different script to what, how they talk about Gaza?
Well, the reason, the underlying reason why the occupation raises very serious questions for other states. So not necessarily, obviously for the Palestinians and the Israelis, they raise loads of practical and direct issues of they're obvious to anyone who have a familiarity with the conflict. But the problem it raises for other states is that it undermines the prohibition on the acquisition of territory by force. So that is a principle that's been very at the core of the international legal order since the Second World War, which is one country cannot attack another country and take parts of its territory. And of course, that principle, the idea is that would limit or minimize conflict, because the incentive of attacking another country so you can steal their resources and their land is removed from the equation, and that the thinking goes minimizes.
Unless you call them terrorists.
But to go back to your question, it's for that reason that many countries, including the United Kingdom government, have consistently taken the view that the occupation should end and that in its place should be a Palestinian state, and it's often referred to as a two-state solution. Yeah. So that is consistently been the position of the British government.
So in summary, the first ground is the Secretary of State for the Home Secretary has obligations under international law to stop genocide, to not provide any material support for genocide, apartheid, and occupation. It doesn't matter if it believes right now there's genocide happening or not. The fact that the arguments are being made and the call is there that there's a plausible genocide happening is enough to trigger her obligation on international law. She, or the government, accepts that there are occupied Palestinian territories, and you're arguing, or the application argues, it's unlawful to provide material support for that. Is that correct?
Yeah, so the application suggests that the Hamas represents the Palestinian people's right to self-determination, at least in the Gaza Strip, and that right of people to self-determination, which is a very well-established principle of international law, includes the right to self-defense and armed resistance, and that includes the right to resist genocide, occupation, and crimes against humanity. And it says that Hamas, at least in the Gaza Strip, is the organization that is exercising that right, and that the British state has a duty also to end those crimes from happening, and that it should do all it reasonably can. And one of the things that the application argues to the Secretary of State, one of the things the Secretary of State can do is to stop inhibiting this armed group from trying to end genocide, crimes against humanity, and occupation. And the prescription, of course, is intended, that's what the application says, that the prescription is intended to inhibit the ability of Hamas to do those things. So that's the argument that the application makes to the Secretary of State, and that she will now have to consider.
That's the first ground.
That's the first ground.
Of three?
Yes.
And the second and third one?
Yes, the second ground is a freedom of speech argument. And so it's not, just to clarify, because I was reading the papers this morning, so there was a suggestion that Hamas is trying to rely on the European Convention of Human Rights for their rights, but that's not I think, quite an accurate way of describing the application. What the application says is that their prescription is a unlawful interference with the right to freedom of speech and freedom of assembly of the British people, and that the Secretary of State, in exercising her discretion as to which groups should or shouldn't be prescribed, should exercise that discretion in a way that is consistent with the British people's freedom of speech. And so what the argument says is prescription interferes with people's freedom of speech, and that's an uncontroversial proposition the application suggests, because the way in which prescription is given effect is by restricting what people can say and do in relation to a prescribed organization. So as we said at the beginning of the interview, it's a criminal offense to express views or opinions that are supportive of a prescribed organization. That of course means that one cannot, if one has those views, one cannot express them. That is restricting speech. It's fairly uncontroversial, the applications suggest, to say that. But the European Convention does allow for restricting freedom of speech. It doesn't suggest that all speech is fine, in the way that sometimes it appears in the United States, where freedom of speech appears to be fairly unrestrained. The approach to Article 10 is to say, is the speech lawful? In other words, is it set in law? Therefore, can you understand what the law says? Which it's accepted in the application that is the case here, because you can, there's a list of prescribed organizations. It's a list that's accessible. People can find it. It's clear. Hamas certainly is aware that they're prescribed, and generally people can find that out. But then the question is whether it's necessary and proportionate. And that question, there's various elements to that question, but the most important element the application suggests is whether or not it seeks to achieve a legitimate aim. And what the application says is it doesn't. That the prescription of Hamas doesn't seek to achieve one of the legitimate aims of restricting people's freedom of speech. That's what the argument says. And what the application says that there is no reason for freedom of speech to be restricted in the UK in relation to a group that doesn't operate in the UK. So whatever may be true for the speech of those who are in the region, in particular in historic Palestine, where of course the prescribed organization does operate, what the application says specifically in the UK, it doesn't operate, it never has operated, it never will. That's what the application says. And so to restrict people's speech doesn't achieve any legitimate objective. Instead, what the application suggests to the Secretary of State is that the reason it's being banned is because the Secretary of State at the time, Priti Patel, disagrees with that organization and its ideas and its objectives.
And when you have Professor Avi Schleim's kind of report that you mentioned, highlighting that this is her own background and her own kind of links to one side of this conflict.
Exactly, and that's what the application does. It sets, as you said, it has all these expert reports, and then it summarizes and explains how that's relevant to the legal argument. And indeed, the application says that the objective here is not to provide some sort of safety for the British public, but it's to stop the British public from hearing views that the Secretary of State doesn't like. And of course, the application sets out that that's not lawful. That it's not lawful to restrict views because one doesn't like them. And that's really the second ground, is to say, regardless of your view of the organization, and regardless of your views of their activities in historic Palestine, the British public should have the right to speak about that organization without criminal sanction. In the same way, the application explains that people who may be supportive of the State of Israel should not be criminally penalized for expressing views supportive of the genocide that's taking place in the Gaza Strip, or the occupation, or the apartheid system that the State of Israel has imposed. just because one disagrees with the views the application says doesn't mean one can criminalize those views. So that's the second ground.
And the third ground?
And then the third ground goes to the overall proportionality of the decision. So the Secretary of State will have to consider to what extent prescribing or continuing to prescribe Hamas is a proportionate decision. And there's a variety of grounds that she's asked to take into account as part of that argument. So among that, for example, are the reference to what used to be called the quartet's preconditions. So back following the election of Hamas, the United Nations, European Union, United States, and Russia called the Quartet, and their envoy, of course, in the past was Tony Blair. They set out preconditions and said, we are only going to engage with the new Hamas administration if they give up their use of force, if they recognize Israel, and if they accept the previous agreements that were reached between the PLO, which of course was dominated by Fatah, and the State of Israel. So those were the Quartet's preconditions. And the application suggests, Secretary of State, that applying those type of conditions to questions of prescription or deprescription would be wrong. So it suggests that in relation to the use of armed force, it makes 2 points. The first is that the right to self-determination of the Palestinian people is well established, and that therefore their right to use armed force is also recognized and is not something that they should be asked to renounce, in the same way that nobody is asking the State of Israel to renounce their right to self-defense and the use of armed force to protect their people. The secondly is the question of recognition, and the point the application there makes is, again, first of all, the State of Israel is not required to recognize the Palestinian state or even the right of the Palestinians to a state before it can be engaged with by other countries like the United Kingdom. And so the application suggests it would be wrong to impose that only on the Palestinians. It also suggests that it's very unhelpful, and it draws the analogy with other historic examples where, for example, the north of Ireland, where of course there were for a long time, as most of your audience will know, there was a conflict there, which was resolved by avoiding, in a way, the question of recognition, and by saying that those who want to see a united Ireland can continue to desire that and can continue to campaign for that, and there may be some type of referendum in the future on that question. And those who wanted the North of Ireland to remain part of the United Kingdom similarly can continue to live in the way that they are as part of being part of Britain, which is why if you go to the north of Ireland, you can cross the border as if there is no border, so that those who consider it all to be a single country called Ireland can live as far as possible that way. Of course, there's different currencies and different street signs, but the idea of recognition being a precondition for the resolving of the conflict, the application suggests that that's not the right approach, and it gives various reasons that Hamas has for not recognizing the State of Israel, but that it has made offers of what's called a hudna, a long-term truce, such that there can be peace in the region, and so that those questions of recognition and permanent settlement can be resolved by future generations. That's the application sets out that point. Similarly, with the acceptance of previous agreements, it points out how the State of Israel has decided to ignore various international agreements, and so the application suggests it's not right for the UK to require only the Palestinians to abide by previous agreements as a precondition for a settlement. So those are some of the arguments being made on the ground three. Others are to do with democracy. And the application sets out how Hamas was elected in what observers called a free and fair election. It explains how it's the civil administration, and so it runs the government in the Gaza Strip, and by equating the entire organization with terrorism, it equates people, nurses, doctors, garbage collectors,
street sweepers, teachers, anyone.
Exactly,
paid by the
and it
ministry.
suggests that type of mass criminalization is not a constructive approach to dealing with any concerns that Secretary of State may have about Hamas.
So, for example, like a Palestinian sending remittances back home, if their relative happens to be a teacher or something, and his or her salary comes from the Ministry of Education, then technically they would be a member of a proscribed organization or something, or indirectly.
Exactly. Well, the application suggests that those sort of questions are very concerning, and that again suggests that it's disproportionate to describe the entirety of the organization as a terrorist organization and all that entails, when it is part of a more than 2 million people's government that runs their lives, and obviously does so far beyond any of the reasons why originally, for example, the Qassam brigades may have been prohibited. That's what the application seeks to explain, and it also, like I said, there's various other arguments under that ground that the application makes, but one of them is the need to reach a political settlement, and it draws from expert reports dealing with the other contexts, similar contexts, for example, the North of Ireland, as I mentioned earlier, but also the South African context. And those experts suggest that prescription may make peaceful settlement more difficult, because it makes it difficult to engage in negotiated settlements, because it's difficult for people to sit down with the organization if they're proscribed. If it's a criminal offense to have a meeting with someone, it's very difficult to have that meeting. And so the application suggests that deprescribing will help facilitate a long-term political settlement. So those are, as short as I can summarize, those are the arguments that the application makes, and it invites the Secretary of State to consider them, and it invites the Secretary of State to exercise her discretion in a different way from that her predecessor did. And those are the questions now for the Secretary of State to consider.
So how do you, I haven't had a chance to go through all of the expert reports yet, so how would you advise people go through these reports? What's the subtext behind?
Well, so they're interesting reports, and the application invites Secretary of State to consider them, and they track a little bit along the line of the factual summary that I gave. So Zionism and British support for it. Then there's reports on the conditions of Palestinian lives in the occupied Palestinian territories. Then there is reports on resistance to settler colonialism, because one of the arguments that the application makes is that the State of Israel is a settler colonial state, and that the Secretary of State to understand the way it acts in its ideology in that context. And so there's various reports that deal with that topic. And then there's reports on the politics of prescription. So, for example, there's Professor Jeroen Gunning, who's written about the politics and effects of prescription, not just in relation to this prescribed organization, but others. And so what one could do, for example, one of the reports that's been included is a submission that was made already in the past by Professor Jeroen Gunning, Dr. Tristan Dunning, Dr. Anas Iqtad, Dr. Tarek Bakouni, Dr. Martin Kerr, Professor Hamish Maxwell Stewart, Dr. Shannon Brinkat, and Dr. Adel Youssef to the Foreign and Commonwealth Office on the prescription of Hamas. That's something that people can find quite easily, and it makes very interesting arguments. And so, yeah, so those are the reports the Secretary of State has been provided and asked to consider.
What consequences exist for the Home Secretary if she just refuses to consider?
So, of course, we shouldn't jump the gun. The Secretary now has 90 days to consider this application, and we have no doubt that she'll do so consistent with her various legal duties. If she dismisses the application, then it will be for the client to consider that decision and to take legal advice onto whether or not there is a meritorious appeal of that decision. If there is, or if they're advised that there is, or they decide that there is, then there's a right to appeal that decision to what's called the Prescribed Organization Appeals Commission. And that commission effectively functions like the High Court does in a judicial review. And so they'll be able to consider whether or not the proper procedure was followed, whether the decision was reasonable and rational, and whether it was lawful or not. But of course, that is, it's a little bit too presumptuous now to suggest that there's going to be that appeal, because the Secretary of State may well say that these are arguments that are correct and deprescribe Hamas for whichever of the grounds that the application sets out. And similarly, the Secretary of State may well refuse and give very good reasons, and reasons that the Hamas considers are persuasive and will lead them to conclude that they should not appeal. So we have to be careful to jump the gun. It's really for the Secretary of State to consider all these arguments now and to take a considered view of them.
What would you say to any critic who's thinking or says the master's tools can't be used to dismantle the master's house?
I would suggest that they speak to Bell Hooks and see what she has to say about it. I don't know if I can say something sensible about that.
Okay. Normally, I've always noticed that lawyers speak very slowly, and I used to think it's because they're charging you by the minute. But you're not charging me for anything. I think the reason you've been speaking slowly is because you're very careful with what you're saying. My question is, what inspired you and gave you the courage to take on this case, considering the obvious risks?
Well, for me, it's very simple. I have expertise that enabled me to assist this client with a legal procedure, and while it's an unusual procedure, it's in effect no different from other public law procedures where I assist clients of all sorts. I have a background in international law, including particularly international humanitarian law, which features quite heavily in Ground 1, as we discussed earlier. And so that combination of understanding public law and understanding international law provided me with the expertise that this client in this particular case needed, and that's why I provided my assistance to ensure that the procedure could be followed properly, and so the Secretary of State could consider this application properly.
One thing that many people might be thinking is, what's next? What about prescribing the IDF? Well,
I think, as I've said repeatedly, that's the big question for the Secretary of State. She does have the discretion to do that. The test for prescription is whether or not an organization is engaged in terrorism, and the definition of terrorism, and that's the application sets that out, is so broad. It effectively covers anyone who engages in political violence. And so the Guardian, actually, their article today, they made a bit of a mistake, because they suggested that not only needs there be a threat of action, but also it needs to be designed to influence the government or an international organization, or to intimidate the public. and must be undertaken for the purpose of advancing political, religious, racial, or ideological cause. But in fact, the definition makes it clear that if one uses guns and weapons of the sort, then the need to influence disappears. So if one seeks to achieve a political objective and uses weapons for it, then the definition of terrorism is met. And of course, nobody can deny that the Israeli forces in the Gaza Strip are using force and guns and weapons and are seeking to achieve a political objective. There may be discussions about what that political objective is, but I don't think anybody can deny that it is a political objective. And so that then immediately means Secretary of State has the discretion to do so. But of course, as I've repeatedly said, how the Secretary of State exercises her discretion is a question for her. The application makes it clear that the definition is wide enough indeed to cover both Hamas, but it also would cover the Israeli forces, as it would cover the Ukrainian forces who are using force to try to expel Russians from their territory, which is a political objective. And so, yes, it's a funny retort, but technically the Secretary of State could do that. What considerations she would have to take, it's not for me to say, and that would be to say for the Secretary of State. But it's certainly something that's within her power. Okay.
Well, thanks so much for your time. Maybe we can have an updated podcast and conversation once you hear back from the Home Secretary.
Yeah, I'll be delighted to continue having the conversation.
Thank you very much.
And thank you for watching at home. If you like this podcast, as usual, give a like and a share, and let us know in the comments below what you thought. Until next time, Assalamu alaikum wa rahmatullahi wa barakatuh.